Uh, what we have is competition law, which is greatly inspired by the European Union system of competition law, as against antitrust laws of USA. There are some distinctions which have been drawn here, and we are following mostly EU model rather than USA model. Our legislation is known as competition law, but the term competition is not defined. So for interpretation, also we rely upon the economic concept of competition, which indicates that it is a process or a state of affairs in the market. In India, we have a parliamentary standing committee, which has also, recognized, some kind of uncertainty of the concept, and has conceded that competition is an evasive term and is understood differently in different contexts. But essentially, it means an economic rivalry amongst economic enterprises to control greater market power. In economics, what we understand is when we talk about competition, it means perfect competition or pure competition, which implies or which indicates that there are certain conditions which exist in the market. If those conditions exist, we can say there is a competition in the market. For instance, there are multiple number of players, buyers as well as sellers. None of the suppliers are price takers, and it is all of them are supplying the homogeneous product, and there is a perfect information in the market, and there are no entry or exit barrier or missed entry or exit barrier. And why do we want competition in the market? Because there are certain economic benefits which arise from this state of affairs in the market as against the monopoly in most of the situation. But in certain situations, monopoly can also be beneficial. For instance, in case of natural monopolies, where it makes sense for one or couple of players to exist in the market, so as to avoid economic, drain on economic resources. Coming to the another extreme of market form, which is monopoly, which is an antithesis to perfect competition, wherein, as the term suggests, there is only one producer and number of consumers, and monopolist determines the price, and which is usually higher than the competitive prices, which sends wrong signals about the value or the cost of product in relation to other products. Why we are discussing monopoly is because cartels are treated as kind of monopoly. They act like a monopoly, wherein they create a situation in the market with respect to the scarcity in the supply of the products, and also they tend to keep the prices higher. That's why it becomes important to understand these two important concepts of competition on the one hand and monopoly on the other extreme. What is the purpose of this legislation is, if I may just highlight in a couple of phrases which have been used, which says, keeping in view the economic development. So this becomes very important, wherein the competition law, the degree, the nature, the level of competition probably varies from economy to economy, depending upon their economic development. So if we are a slightly less developed economy, probably lesser rigor in competition is also acceptable.
I was just wondering, are you advancing the slides? Because I'm seeing just the first slide still.
Yes, I am shifting this.
We only see your title slide. We don't see any of your other slides, Dr. Vahini.
Okay, I'm so sorry. Is it visible now?
Yes.
Now we can see it.
Let me just once again. Is it visible now fully? Full slides? Okay.
Yes, we can see it.
Okay, thank you. Competition law, as I was mentioning, that in its object clause itself, it says the keeping in view the economic development. And also it says for the establishment of commission, which shall have following obligations or following purposes to fulfill. One is to prevent practices having adverse effect and to promote and sustain competition. So on the one hand, they have to promote competition, but only and only by preventing practices which are harmful to the competition or which have adverse effect on competition. It is also to protect the interest of consumer. It may be mentioned here that this is not a competition, this is not a consumer legislation. The protection of interest of consumers are incidental to the protection of competition. So emphasis is on protection of competition, neither protection of competitors or consumer is the direct responsibility of the Competition Commission of India. Then we have another object is to ensure freedom of trade. Again, it is again the byproduct of protecting competition in the market that freedom of trade is also protected of the suppliers or the manufacturers or the traders. There are a couple of definitions which becomes important. First is what are the undertakings or enterprises on which the competition law is applicable. Competition law is an overarching legislation which is applicable to all kinds of enterprises, entities, whether registered, not registered, individuals, natural persons, artificial persons, companies, societies, trusts, government departments. Every kind of entity which is carrying on economic activity is covered under the competition law. There are also issues sometimes which arise between the jurisdiction of competition law on the one hand and sectoral regulators on the other hand. So in those cases also, Supreme Court as well as other authorities in India have clarified how to demarcate the distinction, how to demarcate the jurisdiction of competition authorities on the one hand and sectoral regulators on the other. So enterprise here means a person or department, but there are certain activities of the department such as sovereign functions which are kept out of the purview of the competition law. So sovereign functions, while performing sovereign function, government is not amenable to the jurisdiction of competition authorities. And also there are certain departments which are carrying on atomic energy, currency, defense and space that they are exempted. Apart from these enterprises or these activities, there is no other exemption which can be granted, which is granted under the competition law. So the question sometimes arise whether if it is a policy making, whether it is a sovereign function, whether it will be exempt or not. So if through policy, government makes, provides for monopolies or provides for some kind of restrictions on competition, would it be covered? Because government departments are also amenable to the jurisdiction of competition authorities. Then there is another question which arises, the associations such as sports federations, associations are covered under the Competition Act or not. There are a couple of cases which have been decided by Supreme Court as well as competition authorities that they are also covered, provided there is some test which is, which is cleared by these authorities. What is the test is that if they are carrying on this economic activities, if they are carrying on, if the nature of their functions or activities is economic in nature, irrespective of whether it is profitable or not profitable, they will be covered by the Competition Act. Again, penalty is also based upon the turnover and it is not based on the profitability. So if the entity is earning turnover, penalty can be imposed. That also shows that the test is economic activities and not the profitability. So there are, again, there are a couple of organizations regarding which cases have been decided whether these associations are can be considered as enterprises over which competition law is applicable. Particularly if you look at, we have University Grant Commission, which is UGC, which is a regulatory authority. In respect of regulatory authorities, we are yet to see any case which is to be decided whether they would be covered under the competition law or not. So that's one gray area which is there. Then another important definition is with respect to the agreement. Here, agreement means arrangement or understanding or action in concert. Action in concert becomes important because it is very difficult to, presume certain kind of anti-competitive behavior from the concerted action of couple of, entities which are existing in monopolistic market. So what is the test here is taken from the case which was decided in Duo in respect of the DuPont case. And it says that if there is a parallel behavior in the market, then that would raise the presumption that could give an indication that there is a cartel activity, but it is not a conclusive evidence or proof. We have to look at certain other factors, which is known as plus factor doctrine. So this is important to understand. Apart from that, we have also defined cartels, and also there is an important case of Meru Travels Private Limited in India, which has been decided whether unilateral terms and conditions imposed by the cab aggregator could be considered as agreement, because those terms and conditions are accepted by the drivers and other persons who are associated with the cab aggregator, but whether it can be termed as an agreement or not. Then there are three substantive issues under competition law. First one is anti-competitive agreement. Second is abuse of dominant position. And third is combination, that is with respect to mergers and acquisition. I'm just going to briefly talk about what is the law and how elaborate the law is, which helps enterprises or the companies to guide their behavior, and also not only the language of the legislation, but also the the judgments which are delivered by the competition authorities, which give clarity as to how should they behave in the market. Because this legislation is new, we have hardly covered. The act came into being in 2009, and we have hardly covered 14 to 15 years. So the jurisprudence is still new, the law is still developing. Anti-competitive agreement is the first substantive aspect of competition law, wherein it says enterprises or association of enterprises shall not enter into anti-competitive agreements, and if they enter into it, shall be treated as void. There are two kinds of agreements which are indicated under the legislation, which is one is horizontal agreement and another is vertical agreement. This is only the nature of agreements which is highlighted here, and what are the specific type of agreements are mentioned are clarified in section 3.3 and section 3.4. So if I may just again read it here, is competition law is very difficult to define what is competition, what is a degree or level of competition that must exist in the market. But what is provided in the legislation is that there are certain behavior or certain agreements or certain kind of conduct which is prohibited. And the underlying of all these behavior or conduct is that they should not cooperate. Competitors are here to compete and not to cooperate. So all these kind of agreements which indicate some level of cooperation among enterprises is prohibited. So horizontal level agreement indicates, or some of the examples of horizontal agreements which are mentioned in the legislation is price determination, that is price fixing, limiting or controlling the production of or supply of goods. Third is market sharing, and fourth is bid rigging. These are very common type of agreement which exist among the enterprises who are supposed to compete with each other but are not competing. At the same time, we have vertical agreements. Though vertical agreements are very common in any economy, and they are essential also for the commerce and for the business to run. But under certain circumstances, those kind of vertical agreements, if they impose unreasonable restrictions on on other partner or other party, then they get covered under the competition law, which includes tie-in or bundling, exclusive supply agreement, exclusive distribution agreement, refusal to deal, and resale price. These are some of the examples which are given in the legislation. So this is the figure which indicates the all kinds of anti-competitive agreements, which again has horizontal agreement in particular, and then cartel. There are certain.
Dr. Vahini, your 15 minutes is up. Do you want?
I'm just closing in 1 minute. I'm just
yes,
closing.
Okay, thank you.
Yeah, thank you. Just I'll talk about underlying principles which have been followed, which is in USA we have per se rule and rule of reason, and in EU we have form based and effect based. But in India we follow the presumption rule, that is, if there are horizontal agreement or cartel, there is a presumption of appreciable adverse effect on competition, and which is similar to rule of reason and per se. So thank you very much for giving me this opportunity. I'm very happy to answer any question if there is,
Yeah, thank you, Versha. I don't have a question, but I do have a suggestion. Have you looked into using, for instance, Friedrich Hayek's, the Nobel Prize winning Austrian economist, his view of competition? And also it's developed by an economist, George Reisman, and actually myself, I've written on it as well, how the theory of perfect competition actually excludes all competition. So there's a theory of rivalry in competition that Hayek developed, that where you come to very different conclusions, where from perfect competition or the single seller type of monopoly, where competition is rivalry among producers to engage in voluntary trade and in the context of respecting rights to get people to buy their products. And based on that, the antitrust laws, which these laws look similar to the antitrust laws in the US, actually restrict competition. They restrict those who succeed in voluntary trade, like the Microsofts or the Standard Oils or the Googles. They're just very good at competing because they're very innovative, and that makes actually our standard of living higher. So you might want to look into those authors. I've written a book, Markets Don't Fail, that covers this subject, but Hayek and George Reisman as well have, George Reisman's written a book called Capitalism, a Treatise on Economics, and Hayek, his main paper on competition is The Meaning of Competition. You might want to look into those sources and apply them here.
Yes. Thank you. And I read a couple of cases from US, which you just mentioned, Standard Oil and other cases. Not recently, but a couple of years back. And thank you very much for your suggestion. Economics is slightly difficult for lawyers to understand. So I'll also go into all these economic aspects of the competition. Thank you.
Thank you. That was very interesting discourse.
Thank you.
Anybody else have any questions or suggestions?